When a marriage ends, often the most challenging issues are not related to money or even who's keeping the house. They're the issues that relate to the children. Today, we're exposing the 5 most common issues regarding children that can tear families apart if we're not careful. Our guest today is powerhouse attorney Misty Cole. She has seen it all, both in the courtroom and at the negotiation table, and she's here to talk with us about strategies to deal with these issues in the divorce and to help protect your family. I think the conversation today is really important and one that could change how you choose to fight for your children's future. Misty, thank you so much for being here.
Thank you for having me.
All right, so you've been practicing family law for how long now?
Since 2009.
And why do you do family law? Why did you choose that?
So I started as a civil litigator. I did that for 10 years. And then at that point, I was representing big corporations and insurance companies. And it just became apparent to me that it was more important for me to start representing people who needed my help. And at that point, I'd been litigating, I'd been in the courtroom, and I felt like that could really translate over to family law.
Because I think one of the things people don't understand is that the system for civil law, for those big contract disputes or all the lawsuits between these corporations, is the same system that applies to families.
Right. Same set of rules and rules of civil procedure and same kind of litigation positions. So I think it translated well.
I think one of the surprising things for people is that it's pitting you against your spouse. If you're not really careful about how you approach the default is that
Right.
You've got an opposing party on the other side and an opposing counsel, and all that language of litigation comes to bear when we're in the divorce context.
It does. And it really doesn't have to be that way. Family law can be much more amicable than your usual civil litigation with big corporations or even small businesses. We have the ability within family law to work with the family and help them through that transition.
I love that approach. I think it's one of the things that you and I both share in common is a desire to really help families not get chewed up by the system,
Right.
but really set a clear strategy at the outset so that your divorce is consistent with your values.
Right.
Let's talk about the big issues that need to be decided in every custody case. So we're going to highlight 5 today,
Right.
but these are often the issues that are some of the most contested issues. And I know we're going to talk about kind of why they are contested and then how people often resolve those issues.
Right.
So go ahead. Let's start off with the first issue.
Well, I think the things that people usually think about are things like parenting time, who's going to be the primary, and geographic restrictions. But then I think things like educational decisions and those decisions about who's going to decide about psychological and psychiatric treatment, those 2 areas I think cause a lot of problems down the road that people maybe aren't thinking about when they first are in their divorce process.
Exactly. So I think for our format today, let's kind of start off with a general framework, because one of the things that surprises people is they often call in saying, I want sole custody, right? And custody really isn't even the language that we use in our Texas family law system. So let's talk about basically what is conservatorship.
So we have managing conservators, joint managing or sole managing. Typically, you're going to see joint managing conservators. And that just means conservatorship encompasses things like rights and duties. And can I go see my child at lunch? And can I get those records from the school? Do I have the right to talk to the doctors about healthcare? Things like that.
And for the most part, all parents will maintain those rights of access to information.
Correct.
Right? And of course, there's rights and duties that apply when you have the children in your custody. And so what are some of the things that you get to decide when the children are with you?
Those are things like directing their moral and religious training, emergency medical care, and discipline of the children.
I think sometimes people are surprised to learn although it makes sense, but the courts really won't intervene in the religious upbringing of a child. So if you all maybe shared a common faith during the marriage, but you're going to part separate ways, there's no way to make sure your spouse is going to continue to take them to their confirmation classes or whatever's going on.
Right. And the same thing applies to how you're raising your children and discipline. Oftentimes, there was agreement during the marriage on how they were raising the kids and discipline the children. But as time goes on, one spouse may differ in their beliefs and their views on how to raise the kids.
Yeah. And if the parents aren't in agreement, then the court will intervene, and the court may have very different ideas about how you're going to be disciplining your children.
Right. Typically, nobody's going to be happy with the decision that the court makes, which is why we like to be amicable and try to reach resolutions.
Exactly. So let's get down to some of those rights and duties. And I know I'm visualizing this in a decree. It's like the rights and duties all parents have, and the rights and duties that parents have, all the children are in their possession. So now we're going to talk about kind of how rights and duties get allocated. And you mentioned primary residence. So we'll start with that one. When we call a parent the primary parent, what are we really referring to?
So we're referring to the right to decide the primary residence of the child. So where they're primarily going to reside. It doesn't carry the weight it used to, but a lot of people like the label. And
a lot of parents like to throw the label around too. Well, I'm the primary parent, and they may mistakenly believe that gives them more rights and duties, and it does necessarily. So what do you see a lot of parents agreeing to do with regard to primary residence?
Some parents are now even agreeing to have no primary and just restrict the geographic area in which the children are going to live. We also see one parent taking on that primary designation, but most parents tend to try to live close in proximity, so it doesn't really give parents a whole lot of leg up or clout.
Yeah.
Right.
And, I think it really kind of, as this is evolving, as we see more and more parents moving to an agreement that neither parent will have that exclusive right, it simply is an acknowledgement that the children really are going to have primary residences in both homes. Right. And that's not a bad thing.
No, I think it's good for kids to know that they have a home with mom and they have a home with dad. It's not, I'm, at dad's all the time, and sometimes I go visit mom. We have a home in both places.
Yeah. Now, when we talk about geographic restriction, of course, there is a presumption. Why don't you explain kind of what the usual presumption is?
In most counties, the presumption is going to be that the children live in the same county or counties that are contiguous to that county. But that can be a really broad area, especially if you're in Dallas County.
Right.
That includes Rockwall, that includes Tarrant, and that's a big space. So.
Right. So you could have one parent on the east side of Rockwall and one parent on the west side of Tarrant County, and you all may as well live in separate states.
Exactly. That's a long drive for kids.
It is a long drive. And that primary residence, that geographic area, though, can be very hard to change in the future.
It is. Once it's agreed or it's set by the court, you've got to have a real change in circumstance to change that geographic area. And
oftentimes, if parents are going to do a more equal sharing of time, they will agree to a more restrictive geo restriction, right?
Right.
What are some common restrictions that you see?
So we've seen kind of a move with a lot of people. They want to move to a 50-50 possession schedule. So we see people doing a radius from the marital residence. We see the same zip code, or even a radius from the children's school.
Right. And I've also seen it where they define it by highways, right? So you can have, the Sam Rayburn on the north and 635 on the south.
Right.
Like that. Now, one of the things, parents are often question, why is there a geographic restriction on my residence? And it really isn't on the parent's residence, right? It really is on the children's residence.
Right. The parent can live wherever they want, but the children are going to live within that geographic restriction. And that's just so that they're not having to travel to see the other parent for long distances. It's really about what's best for the kids.
Now, sometimes people, they're envisioning their future life, and they can see maybe moving back to California if their family was from California, or they know they're going to have job changes that may take them, to Austin, or may take them to New York City or something like that. What do you generally tell people about, changing the restriction, maybe while we're negotiating or after the orders get entered?
It's difficult to change a geographic restriction just because the courts don't want the children, having to travel a long way and making it difficult for them. So it's not about the parents. And I know sometimes parents really need to make that move. And there's certainly things we can do with the possession schedule and parenting time. But without some kind of evidence that there is an absolute need to move the children away from the other parent, it's a hard hill to climb.
And it really is. And I mean, the studies show that children do so much better when the parents are in close proximity.
Right.
And that kind of move can have a really devastating impact on the parent-child relationship if you're just not around to show up at the soccer games or, or the events. But sometimes it is necessary. And I think one of the things I would say is that if you think that that's going to be in your future, then make sure you address that early on in the negotiations.
Right. If it's contemplated at the time of the divorce, then you need to address it, because once you're trying to modify, if things were already contemplated at the time that prior order was put into place, it's even more difficult because you don't really have a change if you were already contemplating that move.
Yeah. So those are some of the things we're thinking about, right? When we're talking with clients. The other thing I think about when we're doing the geographic restriction is the lifting of the restriction, right? So if there's a parent, the parents are living in close proximity, and then one parent does decide to move outside, sometimes the geographic restriction will be lifted as to the other parent.
Right. A lot of times in decrees or orders will put in a lift provision so that if one parent has moved outside that geographic restriction, if the other parent wants to move, they can, and that restriction's gone, which may mean your child is moving across the country.
Yeah. So there's just important things to be thinking about. All right. So this sort of those are kind of the residence issues.
Right.
Now let's talk about education, which is often closely associated with residence, especially if the kiddos are in public school. Right. So what are the decisions that need to be made with regard to rights around education?
I think educational decisions can encompass a lot of things, not only where the kids are going to go to school, but if the child has special needs or needs accommodations from the school, those kinds of decisions, and also things as simple as going on field trips or making decisions about classes, or are they going to be in honors? Are they going to take AP classes? All those things I think are encompassed by educational decisions.
But one of the things it's not, as we're sitting here talking about this, and we both have rising seniors in high school, is college, right? So our orders do not address college decisions.
Right. Once the child is 18, the court can't really make orders about college decisions. And once that child is 18 and graduated from high school, the court can't make orders for their support. So things like paying for college are not going to be included in an order.
Right. And sometimes people reach agreements regarding some things, but that can be challenging to enforce.
Right. And there are pitfalls with that and things they really need to think about before making those kinds of agreements.
Yeah. Now, choice of school is one of those issues. So if the kids are in a public school system, that's not usually a big deal. They'll stay in the public school system. But what if the kids are in private school? What are you finding with regard to agreements or court orders for private school?
I'm seeing a lot of issues come up with private school, and courts, I think, are often reluctant to make orders on private school because then someone has to pay for it. Then they've got to make orders about who's going to pay for it. And I think if the parents can agree that, yes, they're going to go to private school and this is how we're going to pay for it, courts are willing to go along with those agreements. But I think it's difficult to get a court to order private school where one parent isn't going to agree.
Right. And I think the exceptions are if there's like a special need or a special reason why a child needs to attend a specific school. But in general, I think the courts don't really view a child having to change schools as a traumatic event.
Right.
And so there's a good chance if you and your spouse are not agreeing on private school that your child may need to be enrolled in public school.
Yes.
Unless you both agree to it. But,
right.
The other thing that I think is challenging with private school is that a lot of schools will go through 4th grade, or maybe they go through 8th grade, and then we're going to have to be picking another new school. And how is that decision going to be made?
Right. That's a tremendous difficulty. And if you can address all of those things in the original order, great. But then you also have issues of who's going to sign that contract with the schools, who's like those sorts of issues.
And even I think one of the not to create problems where there aren't problems, but one of the problems I have seen is even when the parents agree that the child would be going to that school, they still need to sign the contract every year. And if you have a parent who decides they're not going to sign the contract, now we have a court case, right? And we may need the judge to intervene to, require that the parent sign, or to change that to an exclusive right or whatever, but it becomes an expensive legal battle.
It does.
Yeah. So what is your general recommendation? Generally, obviously it changes according to specific situations, but what are you generally suggesting people do with regard to school decisions?
Sure. When parents are good co-parents, I think it's great if they can either have that decision making be by agreement. If there's difficulty in that co-parenting relationship, then I often say it's better if one parent has that right exclusively, and typically the parent who's kind of made those decisions as the kids have been growing up.
Yeah, and I think there's a lot of wisdom in that to, having at least one parent who's sort of responsible for that, because the schools do not want to get involved in these disputes.
They don't. They really don't.
They do get involved, but they often, are not very appreciative of that.
And I think I've even seen lately some schools in their contracts with the parents are putting in provisions that the attorneys are not to contact them or reach out to them to get records, and it's really making things difficult.
Yeah, it is. And I think especially if you have a kiddo with special needs, it's really important to have a point person who is the one calling the shots for that.
Right.
It doesn't mean if it's the other parent making the decisions, it doesn't mean as a parent you're going to be cut out from the information. And, if the other parent is making really crazy decisions, then, you could obviously seek to change that. But
right.
It can streamline things a lot, especially for the child.
Yes.
And that's what I think sometimes we get so caught up in these rights and duties, we forget we're really talking about, kiddos.
I think often parents always say, I'm doing this, it's the best interest of my child. And I think a lot of conflict could be avoided if they also realize that the other parent also believes they're doing what's in the best interest of their child.
Yeah.
So they may not agree on what that is, but most times both parents think they're doing what's best.
And sometimes, the parents separating and being divorced is not the hardship for kids. It's the conflict between the parents. And sometimes knowing when to drop the rope and not do the tug-of-war is really important.
Right.
And can be life-saving for your child.
Pick your battles.
Pick your battles.
Pick your battles.
So moving on to another arena of battles, let's talk about psychological and psychiatric decisions.
I think this is one of the most overlooked areas, I think, by attorneys and by parties. A lot of people will just say, well, we make it independent, which means either party can make those decisions. And those decisions include everything from counseling to medication to inpatient treatment. So it's a broad range, and where they maybe think they can agree on counselors, they get down the road and, well, one party doesn't want them with that counselor anymore, or one party doesn't think counseling is a good idea anymore, but the other party wants them in counseling. And then we've got one party going to the counselor and firing them, and then that counselor won't see the kids anymore, and then they're trying to start with someone else. It really can create a lot of problems, and I see a tremendous number of modifications on this issue.
And one of the big mistakes I think that parents make is if they don't want their child in counseling, they quit communicating with the counselor.
Right.
And they just sort of cut off contact. And that can be really leave the parent in a really bad position when they haven't been involved or engaging in the child's therapy.
Right. Parents should always be reaching out to their child's counselor and staying involved with that counselor. You can always, reach out, get an appointment, even go to counseling with your child, and see what's going on in those counseling sessions.
And I think one of the things that people need to understand when it comes to when we're in a legal system, the legal system likes therapy. We like mental health professionals. And so the judge is going to generally, in my experience, be biased towards appointing a therapist to be working with your child.
Right. most times the judge is going to appoint a therapist. So if you're fighting a battle to keep your child out of therapy, you're fighting a losing battle. They're going to appoint someone, and it may not be the someone you want. So.
And there's also, I think, a sort of a predisposition towards testing. So if a parent wants to have a child tested, generally, the court's going to err on side of having a child tested.
Right. Testing and also medication. When it comes right down to it, if there is a mental health professional saying this child needs to be medicated, most times I think the court's going to err on the side of what the mental health professional is recommending.
Yeah. And this can be really difficult for parents because, you've been the decision maker in your child's life. And the truth is I don't ever discount that what is best for your child. I understand that. It's just understand that if you and the other parent aren't seeing eye to eye, it's going to a judge. And these are some of the things that, are likely to happen. And so if you can negotiate, if you can find a therapist that you'll both agree on, all the better.
Right.
So I think those are valid points. All right. The other sort of fought after issue is invasive medical decisions.
Yes.
So back up for a second, because there are different types of medical decisions, right? There's like routine medical care, and both parents have the right to take the child to the doctor.
Yes.
And then there's emergency medical care. And both parents have the right to get medical care for a child in an emergency.
Right.
But when we're talking about sort of the elective medical care, like a tonsillectomy,
yes.
There are some other cases that have made the news recently. But what do you see with regard to medical decision making?
This is one of the areas where people really dig in. Is on those decisions. And I think a lot of times it's because of the extreme examples, and people really want to make sure that they get to make the decision. So I think it encompasses a lot of things. And I'm seeing lately a lot of people saying, well, what about vaccines? Are they included in invasive medical care? And we don't have a good definition in the family code for what is invasive medical care.
Right.
So, there's going to be some litigation on these issues.
There are, and there have been, and there isn't clear guidance. So it can vary from judge to judge whether a vaccine is considered invasive medical. The pulling of wisdom teeth, those kinds of things. And so the options are those rights, like all the other rights are, they're exclusive to one parent, independent, or joint agreement.
Right.
And of course, if it's joint agreement, then if one parent says no, then it doesn't happen.
Right.
And so what do you see as kind of a workaround for that when you're in settlement negotiations? Because I will say this, the moment one parent says, I want exclusive decision-making, the other parent says, oh, heck no, I want exclusive decision-making, right?
Right.
So now you've got this battle. So what do you see? Where does that usually settle out?
Sometimes we can settle it out at one parent has exclusive after they consult with the other parent, and even built-in time frames so that if the other parent isn't happy with the decision, they can go to court if that's what they need to do, and address it with the court. Or sometimes we build in that if we can't agree, then we're going to take our hands off of it and let the treating physician or the treating dentist we're just going to go along with their recommendation.
Yes. Now, dentists and doctors and therapists too, and we usually do not appreciate it when they named as the decision maker in your child's life and you didn't consult with them about that. You have to be careful how you word that, because it really is, if a treating doctor has made a recommendation, then the parents will follow that.
Right.
But yeah.
Right. We have to be careful not to give them the decision-making authority, but take it out of everybody's hands and just say, if we can't agree, then whatever the physician has suggested, that's what we're going to do.
And the other option would be that it would be the judge's decision, and judges don't like being that decision.
They don't want to make that decision either. No one knows their children better than the parent. So we like to keep those decisions with the parents, but if they can't agree, then somebody's going to decide for them.
Now, obviously, I mean, we have a lot of clients who have very amicable divorce
Yes.
situations, and they see eye to eye, and they really are great at making decisions that are best together for their children.
Right.
But it's not uncommon that divorcing couples are not going to see eye to eye, right? What are some mechanisms that can be put in place to help parents resolve conflict without having to go to court?
Parenting facilitators are great. It's a mental health professional or a professionally trained person that they can go to and kind of talk through those issues and get some input that's, outside of their family that is maybe, well, isn't biased, and can just give everybody a fresh perspective. That parenting facilitator, if they're appointed by the court, can then make a report to the court of what happened in parenting facilitation. There's also go see a family counselor, talk to your child's counselor. But I think getting someone who's trained involved can oftentimes keep you out of the courtroom.
Now, you do collaborative divorce.
I do.
And one of the benefits of collaborative divorce is working with that neutral mental health professional.
Yes.
Why don't you talk a little bit about how you've seen that process sort of help people make really good decisions and avoid the battles?
I think the neutral mental health professional in the collaborative process is a wonderful tool so that parents have that unbiased opinion, that person who's just there to help their family. They're not there for mom and they're not there for dad or either attorney. They are there to help the family. That's the great thing about collaborative, is that it's a whole team of people who are there and their sole goal is to help your family. So I think they can rely on those opinions. And then the neutral mental health professional has meetings one-on-one with the clients or together with the clients so that they can work through those issues and just get fresh perspectives on them.
I mean, it's, I think we take people who, for us, this is everyday lingo, right? We can talk about all these decision making and how they get done and all of that. But when it's your family and you're starting this off, it is, I just want to acknowledge that this is new territory.
Right.
Maybe you've been the one who got to make all the decisions in the family. And now suddenly it feels like your rights are all being taken away from you, right? Now you're suddenly having to share. And I think working with that neutral mental health professional, they really are like a coach.
Yes.
And can help you anticipate problems down the road and really give you some good guidance and counsel. So
yes,
I agree. I think it's one of the great benefits of collaborative divorce.
Absolutely.
This has been really fun. Thank you for coming and spending time talking about issues that people need to be aware of.
Well, thanks for having me. It was a lot of fun.
All right. If you want to learn more about our powerhouse attorney, Misty Cole, of course, she's got a great bio on our website at hargravefamilylaw.com. And we would love for you to check that out. And if you're somebody who's thinking about divorce, or maybe you know a friend or a family who is, please share this video with them and check out all the other resources that we have available for you. Thank you.